I'm here with Boyd Peterson. He's an elder law attorney in Idaho. And first of all, Boyd, thanks for joining me today for this conversation. And second of all, could you just take a minute and sort of explain to me what your firm does and what you do and how it fits into the bigger picture of what we're doing at Elder Guide.
Yes, I'll glad to. Because I was a sole practitioner for quite a few years, and my practice kind of focuses on long-term care Medicaid. And I joined with a firm with Wright Law Offices just a few months ago for a couple of different reasons. But their practice kind of fit together with what I do. They do a little bit more estate planning, just general estate planning. A couple of the attorneys here, and I do some of that, and they have done a little bit of the long-term care Medicaid, but not as much. And that was part of it. They really wanted more of that to kind of fit in with their practice too. And then there's a couple of other attorneys that do some other like business planning and even some litigation and whatever that, and some guardianships and some of those issues that affect elderly as well. Because most of those things come up all the time, even in dealing with any kind of nursing home case. Either guardianships, powers of attorney, all of that. So it really fits together really well, and what you're doing, and just having that information about nursing homes. It was interesting to me even looking at it and seeing how some of the nursing homes rate. And we don't have that many in this area, but there is some. So it's good information to have as they're looking at that. So,
and we tried to find them all. And so, and that's a great point, you hit on there where, there's sort of this dichotomy where you have estate planning firms and you have elder law firms. The best case scenario is probably an estate planning firm that has an elder law attorney, so they can, with the distinction, to me at least, being that elder law attorneys are focusing more on long-term care planning, whereas estate planning attorneys tend to be focusing often on wealthier individuals and a plan that plays out over many years or decades, as opposed to sort of the more emergency type planning you're doing in the elder law field. Right. And obviously, from our site's perspective at Elder Guide, this Medicaid, long-term care Medicaid information is just critical. I mean, nursing home costs are skyrocketing all over the country. I mean, I think the average nationally is $8,000 or $9,000 a year. Many states are, $8,000 or $9,000 a month. Many states are significantly more expensive. And at that rate, a lot of people are going to run out of funds relatively quickly. And so, we love having this information available from experts like yourself. And then, I was hoping also that, one of the things that comes up in many states is, people generically use the phrase Medicaid, but every state seems to have their own name for their program, oftentimes a different name for their long-term care coverage, and then oftentimes separate names for other programs within that realm that cover related services like personal care or in assisted living or home health care. Can you just sort of walk me through, how does it work in Idaho? How many programs are there, and how does the process vary based on whether you're looking to get your nursing home care covered or whether you're looking for a home or community-based option?
Okay. Yeah, in Idaho, it's just called Medicaid, luckily, so we don't have to worry about another term. but Medicaid, there is a couple of different, and there's some different terms that they use depending on who you're talking to as well. But essentially, because you have a number of Medicaid programs out there, and that deal with just your basic Medicaid for individuals who are just low income and so forth. And so you've got a different thing. When we get into the long-term care, we really have, and they don't really use much of a different term, but nursing home care is kind of your main part of that long-term care. And then Idaho had obtained a waiver, which is for home and community-based services. And the home and community-based services waiver covers assisted living facilities and personal care services in the home if they're trying to get those personal care services. So that really, both of those come under that home and community-based services waiver. They actually have different, because they really, if we're talking to someone at the department, they refer to it as the A&D waiver, which is aged and disabled waiver, because there's also what's called a DD waiver, which is the kind of all similar income limits, but it's for developmentally disabled. And so there is kind of a long-term care portion that deals with those individuals that are maybe developmentally disabled who are also needing assisted living or that higher level of care. And really, when we're talking about home and community-based services, the person has to need a nursing home level of care. And I say that kind of in quotes because it's defined in the statute based on some activities of daily living and so forth, right, where their needs are. And so all of those, the DD waiver, the A&D waiver, and the nursing home, all of that kind of is under that same type of level of care for the nursing home level. The DD has some things that are a little different because they have to be developmentally disabled too, but it's still a lot of the same. And really, as a general rule, the rules for income and resources and kind of how Medicaid works is generally the same in all of those programs. There's some minor differences, but most of those differences are dealing with like post eligibility and how income and so forth is counted post eligibility rather than before. So the eligibility rules are pretty much the same. So I hope that addresses the question.
It does. Yeah, no, it's great. And so it leads me to my next question. So, the first step, obviously, to qualify for any of these programs, you have to need a nursing home level of care. Assuming you meet that test, the next steps are you have these income and asset-based tests. And my understanding is, like many states, in Idaho, there's an income limit of like $2,349 a month. And then you've got another $20 exclusion, I believe, for unearned income. So it gets you to, I guess, $2,369 a month. But, it's not like if you're over that limit, you just don't qualify. So, if somebody has $2,500 or $3,000 a month in income, what can they do, and how would you handle that situation in Idaho to try to still get them coverage under the programs?
And that's what, as a general rule, I tell clients: income's not an issue. We can always get around it. There's a way to work with it, and that's and Idaho is an income cap state, so it has that 2369, and if you're a penny over, you're not eligible technically. But there's really mainly two options that we normally use. If they're married, if they have a spouse, then we can use what, under Idaho rules, what we call community property method of counting income. And that's where we would take the total income of the two spouses, combine it together and divide it in half. And if that half is under that limit, then they're eligible for Medicaid. But again, that's only if it's a married couple that we have that option. And sometimes even with the married couple, that still doesn't work because that half is still over the limit too. So in that situation, or for a single person who's over that limit, then we have what's called a Miller Trust, or it's really a qualified income trust, but most people know it is a Miller Trust. And that's really just a vehicle. It's kind of a pass-through trust that just essentially makes the person eligible for income, eligible for Medicaid under the income limit, because it just takes a portion of their income, whatever is over that limit, and we place it into the trust, and then it sort of passes through. But that's really the point, is that and I will tell you, it's always confusing to clients when we start talking about the Miller Trust, because it doesn't really make sense and kind of trying to work through it. But it is a vehicle that allows us to do that. And for a long time, Idaho was really kind of hard in a way to make the Miller Trust work, because they wanted the money to be direct deposited into the account for the trust and so forth. But they loosened those up several years ago, and it's made it a little easier so that we can essentially just transfer money each month from another account to that trust. And as long as it goes into the trust in that month that you're seeking eligibility, and each month thereafter, then they're eligible on the income side. So it's kind of made it a little bit easier. Still not always easy to explain to a client how that works, but that's essentially, it's just moving that money over and then using it, and that makes them income eligible.
Right. And so, yeah, the income test never really seems to be an issue unless you have a person where in the unusual circumstance where their income exceeds the cost of nursing home care or something,
Right.
in which case they're not looking for Medicaid anyway.
Right.
So then it really boils down then, to the asset test. And the asset test, I believe in Idaho, you can have technically only $2,000 worth of assets. But of course, there, similarly, there's a lot of detail that goes into that calculation, and there's countable assets, non-countable assets. You have different rules depending on whether you're married. The first thing I was hoping you could touch on is how does that process work if I'm going to a nursing home and I'm married? What can my spouse keep?
Okay, so that's as you mentioned, the resources, the assets are really the biggest issue in kind of planning and trying to get Medicaid eligibility, and what we deal with primarily. The resources for the spouse who's at home, what we call the community spouse, is dependent on the amount of the resources. So we have to do what's called a resource assessment that kind of sets the value of those resources. And under the Idaho rules, there's a minimum amount and there's a maximum amount. I'm not sure I can tell you off the top of my head those numbers, but the minimum's about $25,000 or $26,000.
Right.
And if the countable resources, again, we're talking countable resources, are under that 25 plus 2,000, then the person's eligible, and so that spouse can essentially keep that 25,000 or whatever. If it's more than that, then it's generally a rule of half. They keep half of the resources, of the countable resources, up to a maximum of 129,000. So, in other words, if they had 200,000, then they would only be able to keep 100,000. But if they're at 250, then they'd only keep the 129,000. So, that's kind of the way that rule works for the community spouse.
Okay. And then, I also want to touch on some of the major assets that people own that commonly and sort of how they're treated. Many of them also, get relatively favorable treatment. The first one that comes to mind is your home. And I was just wondering if you could just go into, how is real estate treated for Medicaid purposes? When does it count? When doesn't it? Is there a difference between my personal residence and a vacation home? And so on and so forth.
Yeah, and the personal residence is excluded as a resource, generally speaking, and that's really dependent on if there's a spouse living in the home, or technically a minor child or a disabled child could be living in the home, and that excludes it. And it really excludes it no matter what the value is. If it's a single individual who's needing Medicaid, then the home can be excluded based on a subjective intent to return to that home, which is really simple. It just means if they were, something happened, miracle, and they could go home, then that's where they would go. So that excludes the home as well. And there is a limit, because if it's over, it only excludes it up to $750,000, which in Idaho, that's not, I've never had that as a problem because the real estate isn't that high. It's heading that direction, but it's not that.
Not there yet.
So as a general rule, I haven't run into that as much of a problem. One of the nuances in Idaho, and I'm not sure that I've seen it anywhere else. Well, of course, I don't know all the other states, but there's a rule in Idaho that says if the home is in a revocable living trust, which we know that's often a way that people use as a planning tool, estate planning. But if it's in a revocable living trust, then it counts as a resource and it's not excluded. So it causes, there's many times that we end up having, and we can just pull the house out of the trust and that makes them eligible. And technically we can put it back in. There's some issues with putting it back in and whether we change the trust or do some other things if it's a community spouse. But that's one of those things, and it's just kind of this because Idaho doesn't really like trust very much, and they don't like it being there, and it's kind of an issue, they put this rule in. And so that is kind of a problem once in a while that we have to deal with. But again, it's not too difficult because we can deed it out of the trust and put it back in or do something along that line once eligibility is established. So, and then with other real estate, any other real estate is a countable resource, but a lot of times what I find, for instance, if it's rental property, because that's income producing property and it's in current use, then that's excluded as a resource. Now, the rental income counts as income, so then that affects that income part of it, but it can exclude that resource in that way. And the other option, there's kind of some tricks with this, and I'm not sure how much it kind of gets a little complicated because it's dealing with who owns it and so forth. But sometimes just listing that real property for sale will also exclude it, and we can get what's called, and the name just went right out of my mind, I apologize, but conditional benefits. And so it's kind of conditional because it's listed for sale. But a lot of times what happens is that property, I mean, right now the market is such that things are selling really fast, but sometimes we'll have like a cabin or something that's, and those, they're not selling that fast. So it might be on the market for a while. A lot of times we can then sort of transfer that to the community spouse. And then if it sells, we can keep those resources. So there's some options there, just dealing with the real estate once in a while. Sometimes it's a little more complicated and the family wants to keep the cabin, and trying to figure out how to make that work isn't always as easy, but it is possible once in some situations.
You know, the next asset beyond a personal residence that most people seem to have these days is some type of a retirement account, and whether it's a 401k or an IRA or a 403b. You know, how are these accounts treated in Idaho? Are these countable or non-countable, and are there exceptions? And how does that work?
In Idaho, and this is, well, it's been a few years back, because for some time when I was practicing earlier on, they were all counted as a resource, and sometimes it was a real issue dealing with those IRAs and how, you know, because of the tax consequences of pulling it out.
Right.
But then they modified that rule, and so the retirement accounts, IRAs, et cetera, that are owned by the community spouse are excluded no matter what. So it doesn't matter what they have; those are excluded and not counted as a resource. For the person who needs nursing home level or nursing home care or long-term care, the IRA or retirement plan is excluded only if they're taking their minimum distributions. Now, technically, that's that required minimum distribution, which you don't have to take until you're age 72 now. But essentially, what happens if they're under age 72, we essentially just have to take a minimum distribution. So we usually just extrapolate back and figure out what it would be at that age and just take that amount out each month. And of course, that's income, that's counted as income to them. And so that again affects that income test, but that does exclude them. And it really just excludes it between 59 and a half and 72, because under most retirement plans, you don't have a right to take it out penalty free until you're 59 and a half. And so I've only had this happen like once, I think, in my career. I had someone who was under 59 and a half. And so in those situations, it is countable. And so we have to work out some ways to try to, you know, deal with that in that situation, but that doesn't happen very often. So, and to me, those retirement plans are sort of a catch-22, because anything that comes out of them is counted as income. And so it sort of ties the IRA up. It is excluded as a resource, but in a way it sort of ties it up, because you really, for instance, the community spouse, and sometimes that's part of the issue. Like I have many times with a community spouse, they have this distribution they need to take, but we push it off and only take it in December, so that it only counts as income the 1 month that they receive it. And that actually is more beneficial to them than receiving it every month. Whereas with the institutional spouse, most of the time we take it every month just because it's easier to calculate, and they've got to use it because it's counted as income to them and so forth. So kind of there's a few planning tricks a little bit with how we use those, but it is. Sometimes it's kind of a difficult situation because a lot of them, there's not, it's assets sitting there that they can't use really to do
Right.
much else.
So I guess it sounds like, it gets somewhat favorable treatment, but from a liquidity perspective, it's not necessarily stuffing an IRA full of cash isn't necessarily the best planning strategy either.
Right.
And then, and other financial instruments that you see are life insurance, annuities. With life insurance, it seems to boil down to, they all boil down to these two different types. You have those with cash value, like whole life or universal life insurance. And then you have policies that don't have any cash value, like term life insurance, which is actually probably more common now. Are these given different treatment, and is one more favorable than the other from a Medicaid asset test perspective?
Well, from the asset test, obviously the term insurance, because it has no cash value, it doesn't have any effect whatsoever on it. The one issue that you kind of run into with term insurance is you're paying premiums on it, and because of, especially for a single person, their income is now having to go towards their long-term care under the Medicaid rules, under the share of cost, and so they really don't have money to pay that premium. But there's some advantages sometimes to have the children or whatever pay that. It kind of depends on the policy, and that's always looking at what is the death benefit, is it worth it or not, to have them pay that. Because if and this is kind of skipping to the estate recovery, but estate recovery under the rules, if life insurance goes to a named beneficiary, then it doesn't. Then estate recovery doesn't have a claim against it. So sometimes using that life insurance and paying those premiums may be a benefit to the children because they may get that policy if they're named as the beneficiaries. So that's kind of skipping to a different issue. But the other, when we deal with policies that have cash value, that's a little more difficult because the cash value counts as a resource. So it's always looking at those policies and trying to determine, is that policy worth keeping, number one? What's the difference between the death benefit and the cash value? Is it better to just cash it out and use that for something? There's been times when we will borrow the cash value. And again, I find with life insurance policies, there's so many different policies and different terms and how they work and what that it is kind of complicated. But if there is that cash, sometimes we can borrow that cash value and use that resource somehow. And let's say the death benefit is quite a bit higher, then because it now has zero value, maybe transfer that policy to a child to own, who can then pay the premiums, but then have the benefit of that death benefit too. So, there's some, and that's just kind of one little option, but it's sometimes trying to deal with that. There is some exceptions. For instance, if the face, I may not say this exactly right, but if the face value is $1,500 or less, then the life insurance is excluded, even if it has cash value. But that's, if it's only have $1,500 face value, usually the cash value isn't very high either. So usually.
Right. So you hit on a number, in the last few minutes, you hit on a number of different planning strategies relating to these particular assets. From a bigger picture perspective, if you have a person who is thinking they're going to need to qualify for, and need long-term care services in the relatively near future, what are some other just general strategies that you like as far as how someone can spend down some assets and try to qualify a little bit sooner?
There's a couple. Again, some of it, as I mentioned, like looking at the real property, that's kind of an issue that comes up. So it really depends on the circumstances, but a couple of others that I always look at is, are there prepaid burial plans? Because they can buy one for both spouses if they're married. So that's a good option to have those prepaid burial plans and purchasing those. One of another would be vehicle, because and actually in Idaho, which it's kind of an interesting thing the way this happened, because it was almost like it was because of the way the computer program worked for food stamps that it kind of carried over, but they actually exclude 2 vehicles if it's a married couple. So one for each individual can be excluded. So sometimes that can be an advantage in saying, hey, we need to update these. They're old, they're not very reliable. Let's go ahead and buy a new vehicle. Obviously vehicles are depreciate, and so it's always not a great thing. But it's really looking at the situation and saying, this would be of benefit, then let's go ahead and buy something that's going to work better for them. So that's an option, because those are excluded. A couple of others. Sometimes an irrevocable immediate annuity can be an option. I don't always use those a lot, but I do on occasion, where that can be very helpful in kind of making things, and really what you're doing is taking some cash assets, and it makes the most sense when we're dealing with a married couple, where we can put those in this annuity that's now going to pay a monthly annuity payment to that spouse. And again, it's because that's income to them. We're really looking at it and looking at those income rules and making sure that it's going to create enough income for them that it really justifies making that kind of a change too. So that's a good option that really can be helpful too. I think it's sometimes, and I've had situations where we're looking and they've got credit card debt or something, or even a mortgage that, paying that down or doing some of those things is also a very good way, because really the goal is to not just spend the money down, but I like to call it reposition the assets to some degree, put them into excluded resources that are going to benefit, especially the community spouse. When we're dealing with a single individual, a lot of these things, there's not as many options. And really it's almost just spending it down and, again, doing a few things that will benefit, like a prepaid burial plan, because we want to make sure that's taken care of. But a lot of it is when we're dealing with a married couple, we're trying to reposition that to be of the greatest benefit to that spouse who's still in the community, so that he or she has the most benefit of those assets as we can possibly make. So that's kind of the goal, I guess.
That makes sense. And it seems like a recurring theme with everything we're talking about here is there's a lot of misconceptions out there about Medicaid, partly because it's very complicated, and partly because a lot of people who work in these fields with people in this age group just tend to not have a lot of insight or a lot of experience with it. And so you regularly hear people say things like, I'll never qualify. That's only for poor people, or if I qualify for Medicaid, I'll only end up in the worst nursing homes, or I won't be able to find one. I mean, is there any truth to any of these things, or is this basically just misinformation?
Generally misinformation. It's interesting, because I have those calls where they say, well, I have too much money. And I say, well, let's look at what you have. And it's amazing how many times when we start going through it and I tell them, oh, well, your IRA is actually excluded. And they're like, oh, and that's, and so it changes the whole picture at that point, and from what they thought was the case.
Right.
Again, because they assume they've got to be poor before they can get it. But, and this is kind of going back to one of the planning tools, but sometimes when individuals have, and I run into this because I'm in a rural community with farmers who their Social Security income is really low, but a lot of times they have assets because they own this land and they've sold it and whatever. But doing an upward revision of the resource allowance, I've been able to keep $300,000 or $400,000 of resources sometimes for the community spouse by going through that process. So again, until you look at the facts, maybe they can have a lot more than what they even thought was possible. There is, and I do have, people say, well, I won't have as good a room. And it's true that Medicaid generally only provides for a semi-private room. And so that's, in the nursing homes, that's not as big of an issue. And even if, I have many times that they'll still be in a private room, even though just because there's not, they're not at capacity or something like that. So I don't think in the nursing home, there's a lot of difference in the treatment. When we move to assisted living facilities, there is a little bit of an issue, because there's some of the assisted living facilities that just simply do not accept Medicaid. And they just say that right up front. And many of the others only take so many Medicaid patients. And part of that, the way that Idaho pays assisted living facilities is really poor. And we've kind of talked about it. They said, well, that's the way the waiver was written and we can't change it. But the amount that they pay is so low that most of them will only accept Medicaid. There's two situations. Sometimes when they've been in the facility and paid privately for a number of years, so they kind of feel like, oh, well, we want to keep them, so we'll accept it. Or they're in a semi-private room, and that's almost the only way that the assisted living facilities will accept it, just because Medicaid pays so poorly. And that is a problem in Idaho with the assisted living facilities, and so sometimes that can be a little bit of an issue. Do they get as good a care? Yes, but it's just the living arrangement might not be as good as it would be. They can pay for a private room if they want, but usually, I mean, it can be, sometimes that fee to have a private room might be anywhere from $1,000 to $2,000, and so unless there's somebody that has money to pay that amount, it's not, it's not very likely that will happen.
And what are they even really paying for when you're in assisted living? Because I mean, my understanding is they're not actually paying the room and board, right? I mean, they're paying for the additional services you're receiving, the personal care and the medical care that you're receiving, right?
Right, and that is because the assisted living has kind of a base rate, which is and then they have their rates go up based on the level of care and how much care you need, and of course, because of those level of care requirements for Medicaid, most of the time the ones who are receiving Medicaid have a little bit higher needs in the assisted living, so the cost's a little higher, and so that's what makes it a little bit more complicated in dealing with that. And yet Medicaid doesn't. I mean, they're daily, because it comes out with a daily rate, and a lot of times I hardly ever see it very high, and so it's it makes it really tough on those assisted living facilities to try to make it work. So,
and so we've talked a ton about planning here, and it seems like there's sort of two layers of planning. The first layer is trying to qualify, and we talked a lot about that. And I love that your phrase, repositioning your assets in order to qualify sooner. But then the second layer of planning sort of comes on the back end here, where my understanding is if you go into a nursing home and you get coverage from Medicaid and then you pass away, they're going to use a tool known as estate recovery to seize a certain portion of your assets. Now, first of all, how does that work? How does that work in Idaho? Are they taking? Is it like probate assets only, or probate and non-probate assets? Sort of, what are the rules there?
Well, in Idaho, I will just say Idaho is pretty aggressive in their estate recovery process, and so in Idaho they will go after any assets that are in the probate estate, and then they've expanded that definition to include other assets that, in a way that pass outside of the estate. For instance, like an IRA has a beneficiary designation, but they actually pull those back in for purposes of recovery and say, nope, we're going to come after that. Anything else that passes upon death through joint tenancy, beneficiary designation. The only exception that I mentioned earlier is life insurance, because there's a specific rule that accepts that if it's paid to a named beneficiary. And so that's really, they're going to pull in just about, and in the rule it has this and other arrangements, which Idaho Medicaid interprets that as broadly as they possibly can to bring in almost anything that they can go after. And Idaho also has a statute that allows the state, and this is really to recover it, and even the way they interpret it sometimes a little different, but it allows the state to set aside transfers. So if someone gifted something within the look-back period, which is that 5-year period, although there's been some litigation where they've tried to expand that beyond, and sometimes the facts weren't good in the case, but essentially they can file an action and set aside that gift and essentially pull that back in.
Wow.
It's not something they do a lot, but it is out there, and so it's always kind of this dagger, this whatever, a sword out there that you never know might cut you down if you're not careful. So
Right.
so they are pretty aggressive on that.
So it doesn't, is there anything, it doesn't sound like there's a whole lot you can do then from an estate recovery planning perspective, aside from the life insurance, which you mentioned, or obviously if you're thinking far enough in advance, you could start transferring assets before this look back period, before the 5-year look back period. But other than that, are you pretty much just at the mercy of this estate recovery process?
You are. And I've always looked at it really, if you really want to avoid estate recovery, about the only way is to give away assets more than 5 years before you need it. And, a lot of the clients, that's not even realistic because they need those assets to live on.
Right.
But there is a couple of, and one thing that I think gets missed often is, and it surprises me how often there's a disabled child. If there's a disabled child, then estate recovery actually can't recover until that disabled child has also passed away. And so sometimes doing some things for the benefit of that disabled child, which there's also some transfer, there's two different sides of that. One is, that's one of those transfer exceptions, is to give assets to that disabled child or to a trust for the disabled child. But it can also extend that estate recovery for a longer period. And most of the time what happens in that is that, and really they'll potentially recover when that disabled child passes away, but at least there's something that can be to benefit that child potentially for a period of time too. And a lot of times estate recovery kind of is gone from that point, and they're really just looking at it as far as that disabled child. Do they get Medicaid that they're subject to estate recovery or not? So
right.
So that's really about the only other possibility that might come up. So,
this is complicated stuff. It's there's so many rules here, and we hit on how many misconceptions there are out there, and so I'm thinking to myself, a lot of people might be Googling this stuff today or reading about it on the internet and thinking that they can do some of this stuff themselves. What's your advice to someone who thinks that they're going to be able to navigate this system on their own and with some do it yourself type planning?
Well, I think it's possible, but it's not very easy. And it's interesting how many times I've talked to clients who have kind of just tried to do it. And part of it is just the way the system works. And it's not like those people at health and welfare that are handling these cases are trying to make it difficult. It's just that trying to meet all of those rules, it takes them like 2 months because they do this and then they say, oh, well, we need this information. Oh, well, we need this information. Right. And so it just can drag on for several months before they actually get Medicaid eligibility. And that's where having somebody who understands the Medicaid program to just help work through that many times can obtain that Medicaid eligibility a lot faster. Sometimes there's confusion about, well, what can I go buy this thing. Well, actually what you bought is another countable resource, so that didn't help, or something like that. There's just so many of those little rules that are difficult to negotiate, and a lot of times they miss. I wish that I had it, because I've had situations where someone comes in and they've kind of started the process and they've started spending down. And when I looked at it, I says, you really didn't even need to spend down. If we'd have looked at this sooner because of this, maybe the upward revision, maybe some other thing that we could have done that would have preserved more assets, but now you're already at this point. So, and it is hard, because a lot of what I do is crisis planning, and many times I talk to someone and they're beforehand, it's like, well, here's so you understand the program and how you understand that it works, and that can be helpful, but so much depends on when you're kind of hitting that crisis too. But the sooner they get into somebody that's a professional, it's really going to probably be beneficial to them in the long run. Even though there may be some cost to that, it's probably going to be beneficial to them to do that than to try to go on their own. That's just my suggestion.
It's sort of one of those things where it's like you're better off to measure twice and cut once, so to speak. And even though there is some cost associated with it, it seems like if you accelerate your qualification for the program by even a month or two, at $8 or $9 or $10,000 a month for nursing home care, it's going to pay for that attorney's fee very quickly if you're dealing with, especially if you're dealing with a qualified person.
Right.
It seems like a no-brainer to me to pick up the phone and give you a call. And that, that wraps up the questions I had. And Boyd, thank you so much for joining me and taking the time to speak with me today and share all this great information, with visitors to our site.
Okay. Well, I hope it's helpful, and I hope it benefits somebody out there. So I appreciate you letting me do that too. I appreciate the time. So.